Sure.
Way too many things in my head. No, say it. No, All right, I think we've got a good crowd today. Before we get started, I am holding someone's cell phone, and I don't know whose it is, but it was left at the front desk. And if you want to be anonymous, I'm going to put it on the table right here, and I will watch it and make sure I don't know how I'll know who's the real owner, but if you're missing your cell phone, here it is, okay? There's no name on it, so. Do I see a taker? No? Everyone check your pockets. I'm really concerned about this. Okay, it's up in the front. All right. Well, welcome everyone to our first meeting of 2024 for the Institute for Excellence in Corporate Governance. My name is Greg Ballou. I serve as our Executive Director of the Institute. And I want to take a moment today to do things a little differently because I think we have a lot of guests in our crowd today because our speakers and co-sponsors for the morning had some friends that showed up. So I'm going to do something a little bit unusual. I'm going to ask our members to stand up and look around and see if you see someone that's not standing. And if you do, say hello to them, okay? If you don't, say hello to each other. Let's just kind of get this started. I want to make sure our guests feel welcome, so.
Yeah, right. Yeah. This guy must be a Methodist. You must be a Methodist.
Baptist.
Baptist, okay.
You recognize
That's close enough. Hey, Catherine.
Yours. You had something on the back. That's it, okay. All right, well, we do want to welcome our guests that are here today. Sean nailed it. I'm Baptist. That's what we do in the Baptist church. I have to be honest, so we do it every Sunday. All right. Well, thanks, and make sure you're say goodbye to our guests as well, so as we wrap up. So good to have you. Okay, now that I started this, it's hard to get it. This happens at the Baptist church as well. We can't get back onto the path. So, all right. As we get going, I also want to take a moment to acknowledge something else going on in the world right now. Some of you may recall reading that Ira Milstein died recently. Like this week, the obituary was in the Wall Street Journal a couple of days ago, and Ira Milstein. If I can get this slide advanced, apparently I can't. I'll get closer to the computer. Of course, it worked earlier. Ira Milstein was a lifetime partner at Weil Gotshal, and he is really known as maybe the godfather of corporate governance. And for those of you that are deeply embedded in this, I know our panelists can speak to this much better than I, as well as a couple of you in the audience. But he was really known for beginning to rock the boat and create the corporate governance culture that we sort of are more accustomed to today. And that all started in the 1980s when he challenged the GM board to take a more holistic view of the company and to, bottom line, try to wrest some power away from a super powerful management team. And of course, that was sort of the model for corporate governance during that era. Management really sort of controlled the boards for the most part. And this whole idea of corporate governance is kind of a more recent development in the grand scheme of history. I mean, 50 years maybe, but still, that's kind of a recent development. And he continued to be recognized as a leader in our profession and died at 97. It was still somewhat active at the end of his life as well. And it's interesting, when I sort of was sharing some of that information with some others, I found out that our prior executive director, Dennis McQuistion, and one of our board members, advisory board members, David Cole, had met Ira at the Yale Corporate Governance Conference years ago. And I just want to read something that David wrote. David said, "What struck me about him was how unassuming and helpful he was to anyone who shared his passion for improving corporate governance and the world at large. One story stands out in particular. Between sessions at the conference, Dennis I attended at Yale, I asked Ira about the impact of different cultures, business practices around the world, and their impact on FCPA enforcement. He lit up and took 15 minutes to walk through his experience and perspective on the matter. He went on to say he found it humorous a Texan would be concerned about what happens outside Texas. Yes, there was a rebuttal to that. Yeah, he will truly be missed." And I thought that was kind of an interesting commentary because it made me think a bit about why we all get together, why we have 81 people registered for this event this morning. And I think that the story David shared sort of relates to that. I think we, number one, want to be better at what we do in the corporate governance world. And so we want to hear great presentations from panels such as we have today and others we've had over the years, but we also enjoy being with each other, the networking, the ability to talk and stand up and greet our guests, and putting all that together really ties into the mission of the Institute, is that's to connect the dots for management teams, boards, shareholders, and stakeholders of an organization. So I'm so happy we're able to do this. I hope you enjoy the purpose that you're here for as well, and that our programming continues to be something that resonates with you. So speaking of programs, I want to mention some of the things that are coming up for the remainder of the year. We have Robert Hall scheduled to speak on April 11th. He's going to address a really relevant topic, and that is, what are some of the trends in society that are sort of sweeping across the nation doing to leadership teams, or what are leadership teams doing to deal with these changes? I mean, one example would be the roller coaster ride we've seen with ESG topics, a hot topic, and then all of a sudden BlackRock never mentions the word ESG again in any of their reports. And so he'll address that. For those of you that have heard Robert, he has a very objective view of what I call sort of controversial topics. I think he'll do a really nice job. For the next program will be a private equity panel that Albert's going to lead, and it'll be tied into a new initiative we've got underway that he'll tell you a lot more about, built around a private equity council that's being formed as we speak, and there'll be more on that later. And then we have a roundtable scheduled for April as well, for members only. Guests are invited to all of our events except for roundtable, and that's an opportunity to sit at one of these tables and share our concerns, passions, plans, opportunities around board activity that we may be involved in. And then we also have a nonprofit certificate program that has 2 more days to run for this semester. We have lots of graduates of that program. I know Lael is here. Lael, where are you? There you are, right there. Lael graduated from that program, and I think others that have participated. One of our speakers used to actually speak at our program, so it's got a lot of traction in the world as well. So those are some of the things that are planned. And then capped off, this is kind of an exposure for our guests for what we have going, is our annual conference, which will be held on October 16th. It's pushed out about a month this year, so mid-October, and we'll have a morning focused on private equity and ESOP issues, and an afternoon general session. So lots of things out there floating around, and we look forward to seeing you at some of those events. I do want to recognize a couple of new members, 3 to be precise, that have joined recently. Karen Bedard. Karen, are you around? Karen, are you here? No. Bruce Cope. Bruce is over here. Bruce, welcome aboard. And Pam Teray. Pam, are you? Yeah, there she is. Pam spoke at our last annual conference, so glad to see you join us. So please say hello to our new members on your way out as well. Also want to thank our sponsors for today. And let me switch gears. I don't know why my wireless is not working, but back a page. Whitley Penn, Holland & Knight, and Texas Capital are all annual sponsors of the organization. And I know Michael Stockham is here. Michael, thank you for joining us. Good to see you again on behalf of Holland & Knight. We have 2 representatives from Texas Capital. We got Todd and Ariane back in the back. Raise your hand. And Whitley Penn, is Randy here today? I don't think I've seen Randy today. But we want to thank all of these organizations for what they do to keep the organization funded, to be candid. Just a couple of things. We're almost there. Okay, take a deep breath. So I do want to mention a couple of administrative things. We offer CE credit, but also today, thanks to our panelists, we offer CLE credit as well. So if you would like to sign up for that, check the front table. There's a sign-up page for execution around that. And you'll also get a survey at the after the conclusion of the event that will be electronic. We love to hear from you, even if it's bad news. We still want to hear, and hopefully it'll be good news. But it's really helpful to get your input as we put together our future programs. So with that, let me get on to what we're here to talk about, and that is D&O insurance, everything but securities class action. So I think some of my director friends have sort of taken the position like, if you join a board, it's not if you get sued, it's when you get sued. And I think that's a very true statement. And I'm sure our speakers will be able to address some things that you can do, but this actually goes beyond what we typically think of as class action lawsuits, and I can't wait to hear this. So leading the charge is Kara Altenbaumer-Price, who is on my left here. Kara is with McGriff, Siebels, and Williams, and she started her career as a corporate attorney with Andrews Kurth and what's now K&L Gates, and moved to McGriff, which 20 years practice. She's well recognized in the community, and lots of y'all, I think, know her already. So we're so pleased you put this together, Kara. Thank you so much. And then Sean Cleveland is the partner in charge of the Dallas office for Baker Hostetler. And Sean is a litigator, and that's, I think you must spend all your time on that from what I can gather. But Sean, thank you for joining us. Sure. And we're pleased that Doug Green has flown in from New York. Doug is the firm-wide chair of Securities and Governance Litigation Team for Baker Hostetler as well. And he has a blog, D&O Discourse blog. And if you haven't had a chance to take a peek at that. So I think we've got three prolific thinkers or deep thinkers on this topic with lots of experience. And I'll be glad to pass the mic around if we get to a point when we have some Q&A. Do you all mind if people ask questions during your discussion? Okay,
We'd prefer it. It makes for a more interesting program, honestly.
Yeah,
so jump in at any time, please.
Yeah, if you ask a question, I'll race across the room and give you the mic. So with that, let's welcome our guests on the panel. So.
I have one question before we get started, because we have different lengths of CLE and CPE. So remind me, when are we wrapping?
CPE is 50 minutes.
Okay, so we need to wrap by 9:10, 9:15?
Yeah.
Okay.
Yeah, 9:30.
9:30. That's what I wanted to know, because I know you guys have places to be, and I didn't want to. And you know these things can linger when you let people talk, so I wanted to ask about that. So welcome to all of you. I know some of you, and I know we kind of got a group of constituents here. I know when you hear about D&O, people are always like, another securities class action panel, which I know many of you are serving with private companies, and you're like, that's not me. So before we get started, tell me how many of you are not serving public companies in some way? So a good portion of you. Well, good for you, because we're gonna talk. Some of this stuff is relevant to public companies, but a lot of what we're going to talk about, and the reason we put this together, is there's a lot of things in that D&O policy that have nothing to do with a securities class action, or they have a relationship to it, but there's more stuff. And so that's the point of today, is to kind of talk about everything else. So with that, just in case somebody doesn't know D&O, I'm going to give you like 2 minutes of just some basics on the policy, and then we're going to start with the questions. So many of you have heard the concept of the A, B, and C sections of the policy. So just to remind you, the A section is the part that's for you if you are directors, that the company cannot touch, essentially. It is for officers and directors when everything has hit the fan and no one can indemnify you. That's essentially what it's for. And we'll talk a little bit, throughout the presentation. We're going to touch on that a little bit. But the main thing is that's the part you don't use a lot. What we're going to focus a lot more on are the B and C portions, which are the portions that are the balance sheet protection for the company. So B is what reimburses the company when it indemnifies you all as individuals. C is the portion that actually pays for the company's costs, whatever those may be. And we're going to talk about a lot of those things. If any of you are CFOs, sometimes you're balancing that concept of your personal needs against you got bills to pay. So that's some of what we're going to talk about, some of the bills that can get paid. The other thing that it's important to remember is with private company policies, they're a lot broader than public policies in terms of what they theoretically cover. And we'll talk about that in just a little bit. But now that we've sort of set the stage on D&O as a concept, Doug, I'm going to turn to you. During our prep, we talked a fair amount about the notion of communications, getting off on the right step. So the matter has come in, and now we have to figure out how to hire the lawyers, how to pay the costs. So talk a little bit about some of the things that you do at the very beginning to get it all started right.
Yeah, thank you, Kara, and thanks everybody for having us. This is a really special opportunity for us to talk to y'all. It is so many shareholder litigation matters are the success of them, overall success, are determined in the first days of the matter. And the very most pivotal thing at the very beginning is to establish a collegial working relationship among the broker, the carriers, and defense counsel. I view it as a triad relationship. And we put our common clients in the middle of that. And as long as those triangle pieces stay intact, you all stay safe and protected. And what are the components that help that happen? Well, first and foremost it is good communication. Communication is key. Securities and governance litigation matters can come off the rails if the broker, carriers, and defense counsel aren't communicating well. And the reason is that if just a basic, everything you need to know you learn in kindergarten is people like to be informed. And it's really important to the carrier representative that when his or her boss walks in the door and says, what's happening on the Acme matter, that the representative can answer and give an update. If we haven't communicated well with the carriers, defense counsel, we haven't communicated well with the carrier representative, then that starts an internal bit of toxicity within the carrier that can cause things to go wrong. Conversely, if Kara and her team as brokers aren't informed about what's happening, then when the carrier calls them, they don't know what's going on, and it all has a ripple effect. And so communication is so essential. It's also important that in having those communications, that the defense lawyer not be overprotective of certain kinds of information. One of the most significant things, and this is important to know, because you can hear this in echoes of this in the boardroom sometimes, that defense counsel doesn't want to share privileged information. Okay? And while it's true that it can be risky to tell a carrier truly privileged information, most of the time we don't need to do that. We can talk about our impressions. So if you're my client and you tell me the background, I don't need to say that you told me that. It just is part of the mix of information in my head. So it's really important that we share candidly with the carriers. That has such important, it builds capital with the carrier too, when the defense lawyers speak candidly with the insurers and don't mince words or get overly technical about legal stuff like privilege. Privilege is super important, but a good defense lawyer can talk around it. And so those are the fundamentals.
One thing I would comment to add from your broker's role in all of this, sometimes when these things get a little complicated, the broker can serve as a buffer in many ways to help people understand what's being asked. And one of the big things that we notice, people, to get back to that notion of what do you share, I have to remind people regularly, the carrier's writing the check. You don't pay bills without getting the bill, right? Like you don't say, oh, sure, I'll just write the check for you, but I don't really want to know what I'm paying for. So put yourself in that same context, or your kids walking through the grocery store filling the cart, you're going to see what's in the cart before you scan your credit card at the checkout. It's the same concept. The carrier's going to write the check. They want to make sure this money is being used wisely. The other thing, it's a contractual relationship. It's not a line of credit. You don't just say, I'm going to draw on that. There are things that are covered and things that are not. And so you've got to keep that open communication there and understand what's covered. So let's get to a little bit about some of those things that are covered that you may not have known about. So I'm going to start just to remind you that we started that level set of, from a public company perspective, securities class actions. That's really what the policy, it's why you buy it. There's a lot of other stuff in it. As private companies, it is essentially an all-risk, a D&O policy is essentially an all-risk policy for business decision making. It doesn't mean everything is covered, but theoretically, unless it's excluded, it might be covered. So I always tell people, there's a lot in there. Call your broker, have that conversation and say, hey, this thing happened. Do I have insurance for it? I will tell you, I recently have a very large matter with a client that's got all sorts of moving parts, many of the things we're going to talk about. And the origination for that thing getting noticed was when my client called and they said, we got this books and records demand. At some point we need to talk about what might happen later if that becomes a securities class action. I'm like, ding, 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 that's insurance, that's covered. And so as just as a reminder, there's lots of stuff. The other thing, even on the D&O policy, to remember is that classic breach of fiduciary duty against directors and officers is covered. It does not have to be a securities case, even in a public world. It still has that much broader protection for individuals, so that's something to remember. And the other thing I'll stop with on some non-securities cases is the notion of there's the occasional coverage for employment cases if they involve an officer or a director. So when those scenarios, because when the employment matter is involving the CEO, we're rising above classic employment matter. So sometimes there's coverage in the policy for that. So just remember, it doesn't necessarily have to go to employment practices policy if an executive is involved in that. So we're going to do a little round robin for a bit here, just kind of talk about some of the bits and pieces that are covered. So next, we're going to throw it back to Doug to talk about the notion of derivatives and books and records.
Yeah. So shareholder derivative litigation, and unfortunately, I mean, Greg's right. The directors very few directors, public or private, have gotten through their board careers without getting sued. It's just a matter of when and for what. And one of the very common types of claims is a shareholder derivative action. We're going to talk about a few of the important policy provisions. And so let me just, having to do with derivative litigation, let me start with just what it is. And I apologize because most of you know this, if not all. A shareholder derivative action is a claim that belongs to the corporation that a shareholder believes the company isn't but should be asserting against people who owe the company duties. And it usually doesn't have to be always, but it's usually breach of fiduciary duty claims against the board for doing wrong things or not doing right things. The matter has different ways it can happen. The shareholder can just file a lawsuit and say that the board is incapable of considering a shareholder demand on the board to evaluate and, if appropriate, bring the claim. And in that case, the shareholder says that the board is incapable of doing that because they're too conflicted. In making the argument that the court should dismiss that claim because the shareholder hasn't first gone to the board, which is a requirement of corporate law, we argue a lot of times that the shareholder hasn't even sought to inspect corporate books and records, as is their right under Delaware law and under other states' corporate law.
And Doug, this would be true for public and private companies,
Public and private, that's right. If you're a Delaware corporation, public or private, LLC, I mean, you need to go to the board first, or plead why the demand on the board would be futile. So a lot of times we argue in saying that they should have gone to the board. We say they didn't even bother to inspect corporate books and records, and over a series of decisions, there's a whole probably talk for a day about be careful what you wish for. So for a long time, we argued that it was a factor that the shareholder hadn't sought books and records that the court should dismiss. So over time, the courts chastised shareholder lawyers for not using the tools at hand, including books and records inspection, before filing a derivative case. Well, lo and behold, what's happened? Shareholders started to go and file books and records and serve books and records inspections on
It's free discovery without discovery rules.
It's free discovery without the discovery rules, right? And so in most public D&O insurance policies, there is a sublimit for books and records inspections. And that is a great benefit to have, but it can also be, in law, what they call an attractive nuisance. It seems like a good thing, but there can be some dangers in it. And the danger is that it sometimes can invite a response that is too robust. Okay? Everything you produce in a books and records inspection can go in a complaint, and it's just an opportunity for plaintiffs' lawyers to twist things and to make allegations that are harder to deal with in a motion to dismiss the complaint that's ultimately filed. It also raises issues of proprietary information that needs to be protected, and it just creates a more complex derivative case when it's filed. The sublimit it's important to comply with that, but it's more important to you don't want to use all the insurance in the sublimit. Essentially, you want to have it because it's nice to get reimbursed for it, but you don't want to use it and overproduce. I mean, I take pride in hardly ever producing more than 1,000 pieces of paper. All right, that is I never want to produce a lot of stuff. Sometimes, though, there's okay, if it costs a lot, so what? We have coverage for it under the sublimit, but that's not really the right attitude. The right attitude needs to be produce as little as possible. I'd add to my standard, I said produce as little as possible without getting sued in Delaware Chancery Court in a summary proceeding. That's not good because you start to litigate issues that are going to be litigated in the derivative case. The defense to books and records production, a defense is it doesn't serve a proper purpose. Well, then you start talking to the court about the underlying merits in a setting where the company doesn't really have a lot of rights. It's very shareholder friendly. So you don't want to get to that point. So it's a give and take. It's an art to negotiate with the shareholder lawyers about how much to give them and what. And that's really where you want to spend the money on the thought part and not the action part, not the document production.
Doug, maybe this is a good time to kind of talk a little bit about the mechanics of how that coverage works and how those sublimits work. So typically in a policy, if you are accessing a books and records sublimit, it usually means there's no retention on that. So it's first dollar coverage. And the reason carriers do that is because, to Doug's point, they don't want you to just do that on your own with in-house counsel and overproduce. They want to have the thought about what's coming down the line. So we always encourage people to use that coverage. Yet it's first dollar coverage, so you don't even have to worry about the retention. And they are trying to get you to hire a good lawyer to be thoughtful, to make the whole matter be cheaper in the long run. Now, what happens when you've got that going, and then you're also litigating the issues, so now you've got a breach of fiduciary duty case going on at the same time. Which bills go to what? So from a mechanics perspective, we typically recommend that even if it's the same firm, and it often is, that's handling the case in court and the books and records production, that they're separate billing numbers and very clear about what's what, because one has a retention. Now the breach of fiduciary duty part, you're still meeting your retention. So you may have a scenario where they're paying, I'm just using an example that I've got going right now, there's a $750,000 limit on books and records, where it's somewhere at 600 at that point, and we're just about to surpass the 1.5 million retention on the other. So the client's got some bills the carrier's paying, some bills they're paying themselves. It becomes a little bit complex from the CFO's perspective about what do I pay, what do I not pay, when do I push back against my lawyers to tell them, no, I'm not paying that bill yet because I need XYZ carrier to review your bill first. So that's one of the things that the broker can do, is to help you navigate through, pay that one, don't pay that one, and then also to call your lawyer sometimes and go, no, you know insurance is here, you're approved panel counsel, hold on. You know how this works. You know AIG, for example, will take a year to pay you. You know that, you accepted the case. So don't bug the client about paying the bill right now. So mechanics, it can get complex when you have bits and pieces all occurring at once.
Yeah, if I can add a thing going back to communication. Books and records demands are very often the first opportunity for good communication with the carrier. Back before carriers, Kara has been a champion for books and records inspection coverage. From a defense perspective, I was a champion for it because without that involvement by the carrier, without the carrier's involvement, the matter grows and can become virulent before a case is filed, and the carrier has foregone, by not covering it, has foregone an opportunity to start to work with defense counsel, start to manage the matter, and so together we've argued for this kind of coverage, and over time it's developed to be normal.
Yeah, in fact, a lot of the sublimited coverage you have, the first dollar coverage you have in a lot of policies, the point overall is to keep the larger matter more in hand. So we always encourage people, use the coverage. Don't say, oh, I'm worried about what happens at renewal, and we'll talk about that a little bit later. But let's talk criminal things. So let's switch paths. And Sean, tell us a little bit about, because you handle a lot of criminal matters, right? Where
I do.
Folks like you are accused of a crime in some way or the other. How does the insurance typically respond, or how do you work with insurance in that context?
Yeah, so it varies widely depending on the type of company and the type of coverage. And of course, as you all know, if you deal with this, it is really important to have an expert broker like Kara who will make sure that you get the right coverages, that you are put on the best footing with the insurance company well before anything happens. And so, I'll back up a little bit and just say, I do handle, excuse me, I do handle a lot of criminal matters, but I also handle a lot of corporate governance, and I handle a lot of internal investigations for companies before something is ever determined to be civil or criminal or securities law related or whatever. And I think that some of the most important things that you can do up front are to have a full discussion early on with in-house counsel, with the people who are handling D&O internally, if those are different people, with your outside lawyers, and talk about where a particular matter may go. So right at the moment that you get an allegation internally that someone says there's fraud at the company, or what we've been telling investors or shareholders is not accurate, or anything like that, sit down with your lawyer and talk about, and a good lawyer will do this with you, talk about where this might go on one end of the spectrum if it's very limited, and on the worst end of the spectrum, if we're not just dealing with maybe some civil litigation, but maybe we're going to deal with some regulators. Maybe the Department of Justice is going to get interested. Maybe more local law enforcement is interested. It's a significant embezzlement case where the DA is going to get involved. Maybe, ultimately, if you're public, the SEC or DOJ gets so involved that they think you've misled people to the point, or solicited money in a way that you've created criminal conduct, or that someone at the company has created criminal conduct. And so when you talk about those things at the very beginning, then you're in a really good position to think about all the different ways that insurance may be utilized, and you're in a really good position to do what's even equally or more important, stop it from creeping down that spectrum to the more serious. Let's try to figure this out and get in front of it, really conduct a thorough investigation, and get in a situation where we know what we're dealing with, and we know what we're going to tell our insurance carrier when we give them notice, so we know our coverage is intact. If we get approached by a regulator, an enforcer, the SEC, the Department of Justice, a DA, anybody like that, other agencies, that we're ready and we know the story. So that's part of it. And in doing that and conducting that investigation up front, you're going to prepare yourself to be able to make sure that you utilize all of those coverages. Now, depending on the terms of your policy, you may have coverage for an investigation itself. And, again, working with somebody like Kara and McGriff, up front, before you ever get in this situation, you need to think about and they'll help you think about all the different coverages you might have, because the terms among different carriers and that you can negotiate in policies are different. You'll often have coverage for the internal investigation before you ever get a subpoena from an enforcement entity, before you ever get a shareholder demand, anything like that. But that's going to depend on the terms of your coverage, and so you need to be in really good communication with your broker, who will be in good communication with your carrier. But there are lots of related things that may be covered. So internal investigations, subpoenas, of course, civil litigation, criminal litigation, even when it gets on that serious end of the spectrum, depending again on the terms of the policy. Most policies will, in my experience, and you really can't overgeneralize, but I should say a lot of policies will actually cover criminal defense of individuals and of the company, and they will cover that up to the point where there is an adjudication by a court.
If the language is
right. You got to really look at the terms, but again, that's where you really need to negotiate this carefully. But a lot of times you'll have the ability, if that's the language in the policy, that it's adjudication language, as opposed to language that's broader that would allow for just an allegation of criminal conduct or, you know, facts that would lead to that, or, I mean, there's a lot of different formulations in the language, but you could, if you've negotiated this properly with your broker up front, have coverage all the way through up until some judge somewhere enters an adjudication that criminal conduct occurred. Now, after that happens, you may, of course, deal with the eventuality that both the company and the insurance carrier will say, well, there was criminal conduct here, we want all that money back. But typically, you've got a completely different set of concerns if you're in that boat. You're not worried about what money you're going to pay back, you're going to be paying back.
You can deal with that later.
You deal with that later. It's kind of like we say and I do white-collar criminal defense as well, not just the investigations, but defend companies and individuals. And what we sometimes say to clients is, you need to quit worrying about the cheese and stay out of the trap. So don't worry about the money, and let's just try to focus on not getting a criminal adjudication. And then you can worry about the money later, because it'll be a matter of you've already had your defense funded, and you may be asked to pay it back, but you can deal with that down the road. Does that give a long, thorough answer to your question, Kara?
So I'll share a couple of things. One is, I've been in this world for a long time, but I've been at the insurance world for 14 years. I have never seen a carrier go back and ask for the defense money back at the end of the matter. Because what's the point? It's throwing good money after bad. There's no, typically things have gone to such a mess, where's money gonna come from? So they theoretically have the right in that context. I've not seen them exercise it. Doesn't mean it hasn't happened. It's just, it's a really infrequent concept. The other thing I would say, this is another time when the broker can be really helpful, and I'll give you an anecdote to explain that. I got a call several years ago from a client. They're like, hey, I just got a call from, that I think it was the CFO. He's like, I have to go to Washington tomorrow because the DOJ wants to talk to me the next day about the company. Do I need a lawyer? Can you help me find one? It's like, yes, you need a lawyer. Absolutely don't talk to the government without a lawyer. And so the next thing I did was I picked up the phone. We did not do a formal, go through the slow claims process notification. I picked up the phone to somebody, and this was AIG. I knew very, very well at AIG. And I'm like, okay, we got, and we talked to the CFO. We got this many pools of people that may be conflicted. So in the course of 2 hours, we decided, okay, this pool needs a counsel, this pool needs a counsel, this pool needs a counsel, and then came back and said, here's some choices, and basically got that thing conflicted out and did all of it within, a few hours. And so it can be done quickly, but it's got to be in a scenario where people know how to navigate it and have the relationships to pick up the phone and say, we'll worry about coverage later. Right now, you have an insured. It's XYZ carrier who needs a defense lawyer. Let's get this done. So that's my point to say, again, it's communication, it's picking it up soon, as opposed to 12 different board members going out, hiring 12 different counsel to eat up not quite enough funds, and then worrying later. So, figure it out up front. So let's talk next. I think our next topic is tax liability. So you've probably always heard there's certain exclusions from loss in D&O policies, and one of those are taxes. One thing, though, I want to point out to people: any of you have do you touch the international world at all? Any of you? Okay. So the tax laws can be a bit different in other places, and sometimes you as individuals have personal liability for those taxes. So in an insurance policy, it's well negotiated. There is often protection for any taxes that you as a person may be assessed on behalf of the company. So it's always something to remember. The policy is probably never going to cover any taxes that the company might have owed, because you got to pay your taxes. But you as individuals never anticipated paying payroll tax or whatever it was in Belgium. So just to remember that there are some opportunities within the policy for those tax payments. There's not a lot to say about that other than just to know it may be there. So let's look at our next topic there, and we'll just continue a little bit. You talked about some coverage for investigations. Can you expand a little bit about particularly the notion of what if you're not the target, but you are the CFO or the CEO or whatever person who's been asked to talk to the government? How have you interacted with the way insurance policies respond to protecting that individual?
Sure. And again, this all is going to depend on the terms of your policy. And different carriers can sometimes be more reasonable and expansive, whatever the policy language is. But typically, when you have a situation where a director or an officer is going to be required to do anything because of something that is covered, you're going to have at least a good argument, and Kara may, add on to what I'm saying here, but you're going to at least have a good argument that counsel for that person is covered. And I will tell you that, again, that goes to the terms of the policy, but I will tell you that carriers don't want company witnesses, particularly C-level, but really any company witnesses going in and sitting down if company counsel is telling them that those individuals need a lawyer. The insurance carriers don't want them going in and sitting down without a lawyer, whether they're talking to an internal investigator, whether they're talking to the government, really in any circumstance. So typically, or a lot of times, you're going to be able to have coverage for those sorts of things. If you don't, the company is going to want to make sure that they pay for that, even where you don't have the coverage. So at the end of the day, that witness needs a lawyer. Any additional thoughts on that?
The only
Kara?
additional sort of practice point I would give you guys, particularly those of you who are on the boards as opposed to in the C-suites, is often the language in that policy, if a particular individual hasn't been called, but it's been said, whether it's the Department of Justice or the SEC or whatever alphabet soup, says we need a representative. The policy language will often require someone to designate that person. So there may be board action that's required to say we designate this individual to go speak on our behalf about this subject. So just ask about that, be aware when that situation comes up, just take a look at the policy to see if there's some particular board action you need to take to check the box on that coverage.
Yeah, and something Sean said is really important. I'm going to keep coming back to this, the communication point and the dynamics of working with the broker and insurers. Sean said that carriers don't want a witness, especially C-suite person, going in without a lawyer. And it's really important to bring the insurers and the broker into the strategic discussions. Because it's a lot of times, sometimes people say the job of an insurer is not to pay. Right? In D&O insurance, that's really not the culture. The culture is that they want to help. They regard themselves as teammates with the broker and defense counsel and the company and its directors and officers, as teammates in the defense of a matter, in helping it stay as low-key as possible, preventing it from becoming virulent. That's the point that over the years I've made to insurers. Please cover books and records inspections. We want you to help. We want you to be involved. I've had the good fortune to defend a lot of cases, but I haven't seen nearly as many as Kara has in her role as broker, and as most insurer representatives have seen in their role. It's a different perspective, but they have a lot of, you and the carriers have a lot of smart things to say. They have a lot of good judgment and wisdom, and it's a mistake, a strategic mistake, not to involve them. You want their money, but you also want their wisdom.
Well, yeah, and particularly if there are active people who are suing lots and lots of companies, they may have already insured situations in which that exact same plaintiff has, and they know the plaintiff's playbook.
Well, yeah, so I have many anecdotes where I've gotten really smart bits of strategic input from Kara and other brokers and the insurers, right? So for example, we had a case in Las Vegas where the judge dismissed everything but one little thing that the plaintiffs actually didn't allege, but that they later said they did, and the judge said, well, maybe they did, and maybe they did, and so we did a strategic move. So that case was heading into discovery. I talked to an insurer, and he had a special bit of he had a case that had a similar fact pattern. And we ended up doing a strategy that stopped discovery altogether and dealt with that loose end. So the case now is finally dismissed, and it never went into discovery. And it was because an insurer representative had seen a very similar thing in Tennessee, right? And if I hadn't talked to him about it, right, I wouldn't have gotten that bit of knowledge, and that case would be in discovery, and it would have been a bigger hassle.
I had Catherine.
I have a question on picking counsel. question.
You
on pick-
anticipated part of the outline.
Yeah, picking counsel. So, an issue comes up, and we all know that Sean is the best in Dallas, and that's who we want to use for this criminal case, but we don't typically use Baker. So how does that get approved by the insurance company? Do you negotiate that in advance? Or, is it, just talk to me about picking counsel when something comes up, if it's the one you always use, or the insurance says, hey,
Right.
you're going to use these guys, but you don't want to use them. How does that all work?
I want to first thank you for that question, Catherine, and the way that you
And the
framed it.
predicate was brilliant.
Thank you, kind.
Well, I will start with, we'll start with public policies and then private policies, because they will differ to some degree from this perspective. The average public company policy, other than AIG, is pretty well the only one with a panel, and they're not even, frankly, that stringent on their panel, although the rumor is they're going to get a lot more stringent. Typically, a public company can pick who they want. You do have to get consent. That's a really important thing that a lot of people struggle with D&O, is this notion of you do have to get consent from your carrier as to who that counsel is. It's not to be unreasonably withheld. So we do find scenarios where the counsel they're selecting is not reasonable in relation to the matter, in relation to the limits, in relation to the skill set. There are many times that a $750 an hour lawyer is just as good as a $2,000 lawyer in the right context. So there's going to be some give and take in that. But to answer your question, it's that communication. It's that discussion up front. How many counsel do we need? What counsel do they need to be in relation to the matter? Now, the pre-negotiation part, you're going to see that more on the private policies, and that's where we see some rate caps that are really kind of, unfortunately, artificially low, particularly in relation to the inflation in legal rates. No offense, guys, but the legal inflation is like, you thought eggs cost a lot? I mean, my gosh, these guys these days.
That's a whole nother panel.
It's a whole nother panel about legal rates. But in your
What's driving
private
that?
company policies, you will often have a rate cap either built into the policy or built into the carrier's rules and regulations that are kind of, in terms of what their litigation guidelines are. So one thing, I typically will go in and try to raise that every year. And so some of that is to try to get them above what the regulations are. So sometimes you can do that. Another things we sometimes do is if there's a particular counsel that you want for your run-of-the-mill business litigation, we will go ahead and have that counsel approved, at least have that discussion up front, which even if the carrier doesn't officially pre-approve them on your policy, at least the process is a little faster at the time. The other thing I recommend that our insurers do outside of the D&O policy is if you know that Chubb is going to pay maximum $650 an hour, your counsel charges $1,000, you can have that negotiation with your counsel to say, I want to keep using you, but I need you to meet me in the middle, somewhere like that, because there's nothing that prevents you from paying the delta, right? I mean, you can always pay more, and I would suggest that your broker should be able to get most counsel approved if you agree to that delta. Now, there's some caveats. There are firms out there that carriers will say absolutely not to. Two categories. One are the people that are known to gin the fees. There are people who are known to overwork the case. And the carriers know that because they, as you point out, they see all the cases and they pay all the bills. So that's probably in your interest, if you really think about it, if the carrier's saying, don't go with that firm that tends to gin the fees.
You don't want them to use up your D&O.
Right.
And all the different levels and pieces of it.
And the other category, if that firm sues insurance carriers, they are never being approved. Just know that.
Yeah.
I was going to add, Doug and I were probably going to add that if Garrett didn't.
Yeah.
So does that answer your question?
We don't.
May I add something to this? This is something that and thank you, Greg, for calling out my blog, D&O Discourse blog. I wrote it to have discussions with directors and brokers and insurers. I started in 2012. I don't write as frequently anymore, but there's still a lot on there. One of the things I've written about over the years is consult CARA, consult your broker, and consult your primary insurer about who's the right fit for the case. Because CARA said, not all lawyers are the right fit for every case. And it's really important to find the right lawyer for your particular case. And it may not be a lawyer at your regular outside firm because of specialty, or lack of specialty, or not even just rates, but the way they approach cases. I mean, you need, some law firms cannot organically litigate, meaning just the way that they approach cases, the way they staff them, they just cannot organically litigate a case that will fit with your economics, right? Conversely, there are some cases where you need somebody who overstaffs, right? If the matter requires that you send a team of 20 lawyers to Germany for a month, then you need a firm that can make their associates go to Germany for a month, right? And that's a particular kind of law firm. So you just got to find the right fit.
Yep.
The back.
Thank you. So we're talking about selecting law firms. In my mind, based on my experience, management does that. What is the board's role in independent, objective oversight as far as the interaction with the law firm?
It's a great question, and of course, the board in an oversight role, not invading the management role, I think nonetheless has a significant role to play, and this is acknowledged by most people in something that's called, you probably all heard the phrase, or maybe you've said it, board safe. The board should at least be satisfied that that firm is if for a serious matter, of a sufficient reputation and quality and with enough expertise across the full range of what you're going to need that for a particular matter, that you're satisfied, that you're comfortable. And that's a little bit of a general answer, but if you think about how it plays out, if you've got a case that before it ever becomes public or anything like it, you recognize that, this is going to pretty much be an employment dispute. And yeah, there's some allegations of, somebody being mean to somebody or whatever, but not fraud or things like that. You can get comfortable with one kind of law firm and you don't have to spend a lot of time fly-specking what your management's doing. But then, if it's a really significant matter, number one, if you've got great in-house counsel, like Catherine, for example, they're going to, in all seriousness, they're not going to put a firm in front of you that you wouldn't approve. But if any of you are in that situation, you do need to think carefully about, is that firm going to have sufficient credibility and resources to do what we need them to do? And just ask those questions rather than trying to insert, firm A or firm B.
And I would add there's a broader economic question to that too. And we're going to talk a little bit about what to do when there's not enough limit. And you've got some tension between the board and the company and the officers and directors. So as a board member, I would suggest you have some responsibility for just making sure that those limits are going to be sufficient to address the larger issue. I think we had some questions.
Got one back here, and then I'll come back, okay?
Well, I think you may have just addressed what I was going to address. What we had, first of all, I chair a public company, but I'm asking more for the people in the audience who are on private companies. There's two questions. One is, a lot of private companies have shareholders on the board, sometimes the majority of such. And therefore, what's that do? That's got to mitigate the risk equation because the shareholders are involved with the board activity. The second is, what we deal with is the amount of coverage that we should have in D&O. And we try to look at that and say, is that value correct? And at the board level, we don't have the understanding of that very well. Our broker helps us and say they do this assessment with the underwriter of what it should be, but help us as board members to address those two issues, the risk of having shareholders on the board helping to make the board decisions and involved in those decisions. And the second is, how do we determine what the maximum, what the dollar value of D&O insurance should be, based on the parameters that would drive that number?
So I'm going to let Doug answer the first part of the question about shareholders on the board, and then I'll respond a little bit to that big question about how much do I buy? Yeah,
so it's a great question. It's a difficult balance when you have shareholders on the board. It's difficult for the shareholder to wear the board hat and not the shareholder hat. It's really tricky, and I'm working through a matter now that involves just that question, and there are issues about if the shareholder is aggrieved, how does he or she take deal with that grievance, right? How does that shareholder manage confidential information that the shareholder knows or believes creates a problem, potential liability by the company or others? How does the shareholder manage that without breaching fiduciary duties by mishandling confidential information? The conflict is a tough thing to work through, and it's just a fact and circumstances based thing, because a shareholder does have shareholder rights too, and it has, right? And how do directors speak with the knowing that maybe the shareholder, that the board discussion is going to give information to the shareholder as a shareholder that the rest of the board doesn't want the shareholder to have, the director to have as a shareholder. It's very tricky. You have to. It's a issue by, you're not only fact specific to the particular issue, but it's a fact specific thing as to just within the meetings, within the, and how do you manage it? And it really is it's an important reason if there is an issue where that is present. It's a good reason to have company counsel present at the board meeting and prepared to be able to ask the shareholder to leave at certain times, to recuse him or herself on a decision. But it's a hard thing. Does that address your question?
Well, it addresses the complexity of the problem.
Yeah.
Unfortunately, you didn't really answer the question. The question is in terms of risk. I would think that if the shareholder, and it has to be a substantial, maybe more than, pick a number, more than 5% reportable. A public company can be more than 5% reportable, right? So if the shareholder's on the board and the decision's being made, and the decision is being challenged by another outside shareholder, maybe an activist, that particular acquisition that you're about to make is detrimental to the value of the stock or whatever.
Yeah.
The fact that the shareholder was involved in that decision, I would think would help mitigate the risk equation attached to any lawsuit
Yeah.
that might come.
Oh,
as an example.
Yeah, I understand. That's a good, okay, that's right. It does. It does. It's appropriate for the shareholder to be involved in the decision. It doesn't, because something's being challenged by another shareholder, doesn't create a conflict. You need to be mindful of that. And it is a helpful protective.
Thank you.
Yes, correct.
I think that's important. Of course, most board members are shareholders.
Yes.
Some are very active shareholders.
Yes.
But as a result of being on a board, often you own stock in the company. So you're, in essence, a shareholder, but you're probably not considered enough weight of shares in order to be counted as an influential shareholder, right?
That's right. That's right. And in defending a claim, right, we argue that why would somebody vote for something, or why would somebody take a particular action as a shareholder? If it were really wrong, it would impact them more than. Exactly. Yeah, that's exactly right. I'm sorry I didn't understand the question the first time.
The limit question is the other question, right? Kara, you want to talk about
Yeah,
that?
I will talk a little bit about that limits equation, and then you actually teed up the next topic, which is activist shareholder
Although we
coverage.
have two
Very
more
well.
questions back.
Oh,
After you do the limit question, we got two more questions, and we can move
so
on.
a little bit about picking limits. As a public company, it is frankly a lot easier to choose your limits because there's a lot of really good data out there, and most major brokers have a modeling system in some way in which they say, if just to use easy math, if your market cap is 100 million and 50 million is held by insiders, then we look at 50 million of public float and we say a 25% drop in stock value. Here's all the settlements over the last 20 years that looked at that. You're probably going to pay 4% of stated damages, plus add whatever these guys cost. So there are. Yeah, so there's some good data out there from a public perspective. From a private company perspective, there's not good data. A lot of it's gut. I mean, any broker can say, here's what your peers are buying. As we all know, your mom told you, just because your friends jump off a cliff, are you going to do it too? It's the same concept, right? So A lot of it has to do with gut. We can offer data, and then in the end, it comes down to what makes sense, what can you afford. I will tell you with a lot of my clients, I joke, it's kind of the McDonald's principle of if I offer you 5, 7, and 10, you're going to pick 7. Everybody picks the medium, right? It's part of what people do. So a lot of it's gut. A good broker can help you with that. One of the things I would say from a structure perspective that I see is missing in a lot of small private companies. So for any of you who may have a policy of $3 million or $5 million, some very small limit, they forget the A side portion. They don't put enough money out there for that sleep insurance for the directors. So at a minimum, it's pretty cheap. I tell people, buy that. I will tell you, take away some of the corporate coverage to put a little bit of that back in there, even if you only have one set of budget. Or a fair amount of carriers will put an endorsement on there that will say, oh, we'll put another $1 million on the top for A side, because they know it's rarely used, but when it matters, it matters. So that's one thing I would say more. When you're picking limits, don't forget the A side. That's probably the best piece of advice I can give you about how much limit to buy on the private side without looking at a specific company.
Back here.
Yeah, so when I was in-house, I had a securities case, and one of the directors wanted their own counsel, and I got the carrier to pay for it. Could you talk about getting the carrier to pay for special counsel for individuals, either board members or officers, a little bit?
Do you want to start? Doug?
Yes, so in general, I think having a united front is preferred, right? So, but there are times when there are differently situated directors or officers, depends on what kind of case it is, where having separate counsel either appear for the director or in the shadows, what we call shadow counsel, is the right thing. Even if it's the right thing, it's still important to make sure that it doesn't disrupt the united front. Set aside cost for a minute. You don't want the plaintiff's lawyers or the judge to infer something by somebody having to have their own lawyer. And you don't want to have the overall defense disrupted by a shadow lawyer who's making mischief, right? Putting demands on just disrupting not just the defense lawyer, but the in-house lawyers. For a very large company, had a shadow lawyer. I had to work all weekend, had to engage a Delaware lawyer on an emergency basis because the shadow lawyer wanted all sorts of very, very sensitive documents. There was no reason for it. And so things can go wrong, even with the lowest key separate representation. But if it's warranted, it's warranted. If I'm defending the whole board and there really is somebody with whom there is a conflict, I can't represent everybody. And again, back to communication is key. Communication is just key around it, and hopefully making sure that the key thing is making sure the individual director who wants his or her own lawyer understands that we're all in this together. And sometimes if somebody isn't in it together, well, then they're not in it together, and we just have to live with that and work around that problem.
Now, from a insurer response perspective to that, most policies are silent as to what they're going to do about that. So if it's a true conflict, you should almost always be able to get that approved. Now, I've seen people go off the rails with the idea, we're all getting 8 different counsel, and when every one of them costs $2,000 an hour, we're going to eat up all the limits. Now, one of the dangers with that, even if your carrier approves that, sometimes they approve it because they can already see they're paying, particularly the primary, because they control how the case starts and all of this. They know their limits are toast, so they'll approve anything, whether it's the right thing or not sometimes. So sometimes you have that. But now I would say there are a couple of provisions to look for in policies. There are some that overtly give the right for separate counsel in the presence of a conflict. You have to state what that conflict is. There are others that affirmatively deny the right for separate counsel without certain conflicts. So just know occasionally there's some language in there, but most of the time it's silent.
Okay, one more.
My question is a little bit of an offshoot to the D&O insurance directly. I want to double back to the criminal topic a minute. As a private company board member, I haven't pondered a lot about criminal activity or criminal situations for like board members. Clearly for officers, it's a little bit easier to see how the various scenarios. Could you give a couple of examples of things to look out for from a criminal activity perspective that board members could be liable for?
Yes. You have a much greater exposure the closer you are to the criminal activity at issue. So for most board members, that's going to be a pretty remote possibility. The kinds of things that takes something from civil breach of fiduciary duty type claims to a criminal claim are really intent factors and knowledge factors. So to have criminal exposure for a board member, what you really would need to have is some criminal activity where the board member is aware of and turns a blind eye to it, what we call willful blindness, or actively participates in it. And that comes in the form of, to get even more specific, documents or documentation of board meetings where you had got an email or you were at a meeting where they said, hey, we're doing this. I'll give you an example that's sanitized, but it's a huge case I'm dealing with right now where the company is a really good company, but they had a few bad apples in a small part of the company. And what happened was essentially the company didn't think, and rightfully didn't think, that enforcement authorities had ever brought an action against a company for activity that was really with a third party that they were dealing with, wasn't even their own conduct. But that creates real problems when you have some knowledge that you're dealing with even a third party where it's not your conduct that you think may be engaged in criminal conduct. So that's the kinds of examples I could give you. You shouldn't stay awake at night worrying about the criminal aspects of it. For all the people in this room, it'd be hard to imagine a scenario where you would see a company doing something like that and turn the other way. But you do need to be alert to it because it creeps in sometimes, even with the best of intentions.
And there's insurance for that. So
There
let's
is.
talk a little bit about one of the other things is the notion of, we've alluded to the idea of activist shareholder coverage. So sometimes you've got somebody out there making noise, right? And there's not a case yet, there's not anything like that. So one of the things that a lot of people are surprised to find is in your insurance policy, there probably is some coverage for dealing with an activist shareholder, and that could be you're hiring the crisis firm, you're hiring the communication firm, you're hiring somebody to tamp them down, essentially. And so a lot of times that is first dollar coverage as well. So with that'll probably talk about crisis communication coverage a little bit and how that plays into things, and then we'll turn to some other topics.
Yeah.
So those are interrelated.
Yeah, so crisis communications, from my perspective as a defense lawyer, are very important. They're very important to do right, so in various ways. Crisis communications can help us defend the case better. We can use information in motions to dismiss before any discovery happens. So that's where a lot of my energy goes up front. We don't want things to go into discovery. We can use good crisis communications to put into our dismissal papers. So it's important to do it. It's also important to use the supplement to look to the coverage, see what it is, see if there are any insurer rules about whom to pick, whom not to pick. But then use the coverage. I mean, it can be abundant coverage and plenty of room to get somebody really, really good.
It's typically 100,000 or more.
Yeah, and so I like to set up my philosophy is that the corporate, we need to protect the company, and that's goal number one. That's the point of it. But in a situation where there are legal matters that we're defending, we need to really stitch together the defense and the communications, not just to help, but also to just prevent the harm. And the harm can come from stray words that can be twisted, unnecessary hyperbole. So it's important to have defense counsel looking at those communications because they can be focused on protecting the company while doing no harm in the shareholder case and doing some good. One of the issues that I worry about when there's a need for crisis communications is protecting the candid communications between the company and the professional. I like to hire PR people myself. I like to engage them. I like to do it because I can keep a lot of the discussion privileged if I do it that way. The law on that is sometimes not protective of privilege, but it's better to set it up that way and work to protect it than to never have it protected, because not having it protected can cut down on the candor in the communication, and it can of course result in discovery of, if the communication is candid, it can do some real harm down the road. And so I like to hire the people, the PR professionals, to work with me to help me give legal advice and representation to the company. That way it can be at least argued to be privileged and protected, what we call attorney work product.
And going through your attorney to reach that crisis firm should not have an impact on the coverage on the crisis. You still presumably are going to have that sublimit. It's still going to be that first dollar sublimit most of the time. It's just, again, one of those things you want to be coordinating with your carrier as opposed to sending them the bill after the fact.
That's right. And sometimes for public companies, a common situation that makes you think about having crisis communication or doing it yourself is a hit piece by a short seller. The short sellers, there's a high correlation between short seller hit pieces and securities class actions. We're not talking about securities class actions, but it's in that...
Alphas of the world.
What's that?
The seeking alphas of the world.
Exactly, yeah. Right. And it's important to get good advice about whether to respond, how to respond if you do. And that advice is somewhat crisis communication, but it's a lot defense, because I won't get into the minutia and the different considerations, but it's really important. Some of those first steps in those short seller attack, shareholder litigation matters, can be dispositive.
All right, so we've got a few more topics we're going to cover, sort of personal asset protection, counterclaims, how to deal with those. Before we go to those, let's talk about key TAM, and for any of you who may be doing some government contracting, things like that, how have you seen insurance policies respond in key TAM matters?
So, if you are dealing with, again, a subpoena or court-ordered testimony or involvement with the government, that is frequently going to be covered under a D&O insurance provision. You're frequently going to have those kinds of terms that'll cover that. In terms of healthcare and key TAM liability or healthcare fraud liability in general, well, let me back up. How many people in here are involved in defense contracting or healthcare? Okay, so we've got a couple of people, but a pretty limited number. So you know about this, and I'll keep it high level for the rest, but a lot of times you're not going to have the same level of coverage that you would for something like securities litigation, for an SEC subpoena, things of that nature. But again, it's all going to go back to the terms of your policy, and if you've got a need for that sort of protection, if you're in a highly regulated industry like healthcare or defense contracting, where you're going to be submitting to a government payer, whether it's Medicare or the VA or
road contracting, any kind of things.
Road contracting, any kind of things. You've got to be very mindful about having coverage that has specific terms that are going to cover that, so that you've got language for subpoenas, you've got language for trial, you've got language for litigation that deals with any kind of fraud that you expect to confront. So if you're in healthcare, we're talking about the False Claims Act, key TAMs, in the civil context of that. False Claims Act can be brought criminally too, but anti-kickback statute. For defense contracting, again, it's False Claims Act. So if you're submitting a claim that has some element of falsity to a government agency, you've got to be able to tie your coverage to some specific term in your insurance, whether it's the word fraud or whether it's something of that nature. I will tell you that frequently, however, in my experience, and most of the time in my experience, and I've done a lot of healthcare and defense contractor fraud, this is not going to be something where the companies aren't typically relying on insurance.
Insurance is on the margins.
It's really on the margins, and the companies, there's a lot of reasons for that. And Kara, you may want to go into some of that, but typically defense contractors and healthcare companies, they're paying our bills directly on those kinds of things.
One comment I would say that makes it a little bit complex, and this is one where you have to tread lightly, is that notion of all D&O policies are claims-made policies. So these sometimes are matters that are under seal. You're not allowed to talk about them. Theoretically, they were filed years before you may know about them. So you can run into some tricky questions as to when was the claim made. So that was one of the sort of insurance points, is you really are going to have to, your broker and your counsel are really going to have to work hard to push the carrier to pay something if it arose 3 years ago and you're just now able to talk about it. So that's an important thing to think about. So we got just a little bit of time left. Let's talk. I want to just remind you guys that a lot of the policies have something called personal asset protection for those of you as individuals in them. And that essentially means that if something is going on and someone is trying to freeze your house, your boat, whatever it might be, there's typically some coverage to keep them from freezing your personal assets as directors. So it's a fun little bit that a lot of people don't end up using, but it's there. Let's talk about counterclaims. So that notion of you're the plaintiff, and the matter is ticking along, and then all of a sudden the other side files a counterclaim. So talk a little bit about where you've seen, how that works and how, wow, there might be insurance.
Yeah, so you just beware that if you or your company's a plaintiff in a case, you get a counterclaim back, it's good practice to run that by Kara, because the counterclaim allegations may be covered. And it's important to know that. If you're a defendant and you assert a counterclaim, you're an insured defendant. Your insurance is covering your defense, but you assert a counterclaim. The counterclaim isn't defensive. It may not be deemed to be defensive, and so not covered by the D&O policy. And then it's important that you segregate, or have your counsel segregate the billing between the defense, which is covered, and the counterclaim, which may not be covered. And even if you think it should be covered, you should still segregate it so that then you don't get denied the proper defense. If it's commingled, then the insurer will put on you the burden to untangle it, right? And so you want to keep those separate.
And I'll share an anecdote from a client of mine. We were in the back seat of an Uber, and I knew they were the plaintiffs in a breach of contract case, which many of you know, breach of contract is typically not covered by insurance. And she had to take call from counsel, and then she hung up, she's like, yeah, it's so annoying, they just countersued us for fraud. And I'm like, hold on, hold on. And they had not even occurred to them that D&O might be involved, and I think they're about $500,000 into receiving some funds from the policy, because it's really turned into, the case is really about the fraud counterclaim more than anything right now. So sometimes, yeah, it's important if it's going both ways. And that takes us to, we keep promising to talk about what happens when there's not enough money. What happens when you're trying to prioritize you guys versus the company? So Doug, I'm going to let you start with that. First of all, let's talk about some of the mechanics as we answer to all of this, both of you. The mechanics of the separation of the bills. We have multiple billing numbers, thinking through that. And then also, what if this is a matter that's a bet the company matter, but we're going to run out of insurance? Yeah. So how do we address these things?
Yeah. Well, just let's take the mechanical part first. It's really important to have, I assign a different matter for each component, even if they overlap, and even if probably it's going to, because you never know how things are going to be treated. For example, I have a set of matters now, a matter, and I have 7 matter numbers, because there's some of the there's a derivative investigation, but that has to be handled separately. There's a matter that was filed with a shareholder that with some separate circumstances, too complex to explain what it's about. But and then the SEC thing, and so I've subdivided it because the coverage could be different on all of it, and it's kind of a pain in the neck to bill it that way. But it's better safe than sorry, because it's going to, just from a practical perspective, I don't want to take 20 hours of time trying to go back and figure it out later.
And one thing I'll interject on that is don't deny on behalf of the carrier. Let the carrier do the denial. So if you've got a scenario where it might be covered, might not be covered, I don't know, put it in the portions of the billing that you anticipate will be covered, and then let the carrier deny it, let the broker fight over it. Don't presume they won't cover it. Why not submit it?
That's right. And I separate, there's another category of work in just about every matter that the carrier, I know the carrier is going to say isn't covered, and that's updating the 10K for the lawsuit, talking about doing work on indemnification, making sure that the advancement requests have been made and that the undertakings to repairs, all that stuff. It's not a lot, but if that finds its way into the defense bill, the carrier starts to be suspicious that there's other uncovered stuff in there, and they go looking for it. And so I not only separate, and I let the broker talk about the corporate, what I'll call corporate work, but I tell the insurer that I have a separate bill for the uncovered things, and it results in much less scrutiny of my bills, right? And many fewer deductions or questions about what this was about or what that was about, because they know that I attempt to segregate and deal with it in a different way.
Now, Doug, maybe you could address some of these questions about, Sean, maybe you could address some of these questions about when there's not enough money. And I like to call it the Jeff Skilling problem, right?
Sure,
or the Enron problem, right? There's only so much money, it's all going to get used. How do you start to manage between who ought to be prioritized and who gets to use the money first?
Yeah. So this is where managing counsel for all the different officers, directors for the company becomes really key, because what you've really got to do in a situation where you're going to run out of D&O money is make sure that everybody realizes that it's in everybody's defense or in everybody's interest for everybody to have a defense. Now you can get in some situations, and I've been in them, thinking about Michael, we were in one, where you've got such a disparity of interests, where some people think they are just, so in a different position than other people that you just cannot harmonize them. And that's going to happen. But by and large, you want to keep those counsel coordinated so they'll all do what's right and try not to overuse those D&O proceeds on behalf of any defendant. Now, what happens when you get people who are unreasonable is then the gloves start coming off, and that's what happened in Enron. I represented, as an aside, I represented Ken Lay along with others in both. He was the chairman of Enron, for those of you who don't remember. But in the security, I defended the securities class action litigation and the criminal case. And the directors in that case felt that they were in a very different position than officers, and so they made a demand on the carrier for all of the proceeds. They said, we want to settle this civil case over here. We don't have criminal exposure. We want to settle it, and we're making a demand on the company. Now, as all of you probably know, when that demand is made, insurance is on a first-come, first-served basis typically. And so the carrier is required to pay out a legitimate demand, again, depending on the circumstances. So the only thing that you're left with in that situation is a threat or the actual lobbing in of a separate demand. And that's what we, in effect, were doing on behalf of Ken Lay, and Skilling's counsel were involved in this too. There's different levels to which that's effective. I've had it be effective in some cases. I've had it not be effective in others. But that's what you end up doing, is saying, look, we're going to make a policy limits demand too. And so we're going to be having conflicting demands here, and that's not going to be in anybody's interest. All the money's going to be gone. It's going to go straight to these plaintiffs. None of us are going to have defense cost funds left. So let's all just, get back together and work on this. But it doesn't always work, and Enron is a case where it did not work out well.
Well, and it's interesting. I've seen this scenario many times. we had one of the witnesses at my company, so I wrote the sentencing memo for one of them.
Yeah.
I don't think there's a lawyer in Texas who was practicing in this space in that era who did not do something in relation to Enron. But
Yeah, right.
so we see these scenarios. One of the times, it's been a hard challenge sometimes as the broker when you have all these competing interests. And I have just in the last year had one where the company was on fire. I had one C-suite saying, don't talk to the other one. And the CEO and the CFO were saying, don't talk to each other. And I'm like, I'm sorry, you're both my clients. I don't have a choice. You both have full access to this policy. So I always recommend that people coordinate amongst yourselves. Because if you don't, you will end up with this first come, first serve problem. And I've definitely had some where you have to negotiate that before, where you're like holding back some bills, sending some bills first, sending some bills second. There are some policies that actually, you can put language in a policy that basically says when this scenario is going to happen, there's a committee of the board that will decide how the bills get sent. But one of the things I remind you guys is it is a directors and officers policy. The company is covered, but first and foremost, outside directors rank first, inside officers rank second, the company ranks third. So when it really is a matter of we have to decide, and a lot of times the carrier they'll put the halt on it and say, we're not paying bills till we figure this out, right? So they will kind of work together to make some of these decisions. But when it comes down to it, if you don't figure out how to negotiate yourself, outside comes first.
Yeah, and another scenario that's less exotic than Enron is you have a broker or somebody other than Kara, and you don't have enough limits to manage all these things. You don't have enough limits to litigate down the road if you need to, and you try and you lose the motion to dismiss, and how do we manage? How do we resolve multiple cases? Securities class action, shareholder derivative litigation. There's an SEC inquiry. And it's really important in those situations to make good decisions about return on investment. And a lot of thought, and it's boardroom discussion, I think, at this point, where you have $15 million and you have $25 million worth of potential liabilities, to upfront talk about how you're going to manage them. And some of the solution, maybe I have a matter now where we're litigating, we're spending money on defending a securities class action because the plaintiff simply won't take a reasonable amount that will fit within the insurance program. So everything we do, we think about, are we going to get return on the investment, right? And it does look like we're going to end up we're going to be able to get them down into the right zone by spending less money than we would, right? The return, we're getting a good return by litigating. But it's a board level discussion because the consequences are serious if we don't make it work right.
Kara, we're down to a few minutes.
I was just going to say, I see you over here in the corner of my eye. So we've had this theme the whole time about communications. I'll close with two specific nuggets about that. Communications, one is notice early, notice often. Do not wait to notice your carrier. The meter does not start running until the carrier has notice and has accepted that notice. So just be aware of that. Don't spend money without talking to the carrier first. And then that gets us back to the communication in relation to consent. Consent to counsel, consent to settle. So if you don't get the carrier's buy-in on those, you're going to have trouble actually making the insurance policy that you had work. So I think we've got housekeeping. Don't forget to sign in on the CPE and the CLE if you want your credits. You sign in on that. And then I'll do a little plug. Michael Stockin back there had his first novel come out a few months ago. It is excellent. Go buy it. It's on Amazon.
We will. We can't wait. Well, let's give these folks a round of applause. Thank you so much for your time. I also want to note that McGriff and Baker Hofstadter have sponsored this event this morning, so thank you for your sponsorship as well. So made it very attractive. And that was a super informative discussion. I learned a lot from listening to you guys, so I hope you did as well. So I look forward to seeing you at our next event, and we will call it a wrap for today, and hope everyone has a great remainder of their week. All right, bye.